Hello friends, welcome to part 2 of our 3-part series on relocation with children. Today we're going to cover what happens if you relocate with your child or children without the appropriate court order, and I can tell you it's not going to be good. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Let's talk about some of the negative consequences should someone decide to relocate a child without complying with the requirements of the relocation statute. Number 1, the person improperly relocating can be held in contempt of court. That is never a good thing. Number 2, the court may order the child to be returned to the court's jurisdiction. If the parent relocated improperly, they took them, for instance, to California, they thought that they were going to get away with it, the court may require them to bring the child back immediately and at their own expense. Number 3, if it is an initial determination or a determination of a modified time-sharing schedule, the court can consider the improper relocation. It can also consider whether or not the parenting plan that is initially in place should be modified because of this improper relocation. The court can also require that person who left to pay the attorney's fees of the parent who had the fight to return the child. Finally, the court can order that the costs of returning the child or the cost of that person traveling to see the child will be borne or paid by the parent who improperly relocated. These are pretty stiff sanctions. So a tip for those who are contemplating relocation, it is always important to follow the law and follow the relocation statute to the T. All right, so now that we discussed the sanctions and we spent a little bit of time talking about the parent who wishes to relocate, it's fair now to discuss a little bit about what the parent who objects to the relocation has to do. The first thing that the Florida statute requires is that the parent that objects to a relocation must file the answer or response, and it must be sworn or verified. In that verified answer or response, the person who's objecting to the relocation has to give a specific factual basis supporting the reasons he or she is seeking to prohibit the child from relocating with the other parent. In addition to this, there has to be a statement of the amount of time the objecting parent is involved currently or has been involved in the life of the child. So it's important for the parent who objects not to just write down, hey, I object. No. When it comes to relocation hearings, one of the things that is very unique about this particular statute is that the court is allowed to have a preliminary hearing to determine if there's going to be a temporary rejection or restrainment of the relocation, or if the court is going to allow for a temporary order relocating, allowing the child to relocate. And this preliminary hearing occurs relatively quickly after the initial petition for relocation is filed, usually because the school semester is going to start, it kind of makes sense, or maybe there's some sort of family emergency. So what happens at these preliminary hearings, they're a little bit shorter hearings, and the court is going to make a determination as to whether or not there's a temporary order allowing for relocation or denying the temporary relocation. Also keep in mind, at the preliminary hearing, there's going to be evidence introduced that have to do with some of the factors that we'll talk about in video 3. All right, as we travel down the Florida statute for relocation, let's talk about some of the temporary orders that may be put into place. The first temporary order that we'll talk about is a temporary order restraining relocation. A court can enter an order temporarily restraining relocation, or if the child was already relocated inappropriately, an order returning the child if the court finds, number 1, that the petition to relocate does not comply with subsection 3. Now, remember last week we did a video and we talked about what is required in the petition. Well, what is required in the petition in subsection 3 is all of the geographical and other information like the description of the new residence, the mailing address, the telephone number, the date of the move, specific reasons why, a proposed post-relocation schedule, and then the all caps. Well, if the party seeking to relocate fails to comply with that subsection, the order may restrain or prohibit the relocation on a temporary basis. Number 2, that the child has been relocated without written agreement or a court order. So the court can restrain relocation if the child was improperly relocated. And then finally, the court can examine the evidence presented at a preliminary hearing. These cases have preliminary hearings, and based upon a likelihood that the court will not approve the relocation, the court can restrain or prohibit relocation of the child. Now let's talk about when a court enters a temporary order approving the relocation on a temporary basis. The court can enter a temporary order allowing for relocation if the court finds, number one, that the petition to relocate was properly filed and complies with subsection 3, which is what we just spoke about, and the court determines from an examination of the evidence presented at this preliminary hearing that there's a likelihood that at the final hearing the court will approve the relocation of the minor child. These findings must be supported by the same factual basis as the court would consider in a final hearing. What's interesting about the statute is that it continues to read that if the court allows for the relocation of the child, it will not be able to give the temporary relocation any weight when it comes to the final hearing. And finally, what's very interesting is that if the temporary relocation is approved, the court may require the person who is temporarily relocating to provide a reasonable security, meaning financial or otherwise. This means that if the parent's allowed to temporarily relocate, the court may require a financial bond to be paid to make sure that the parent who's allowed to relocate won't just abscond and leave with the child. All right, one of the last things that we're going to cover on part 2 of our relocation series is a fascinating part of the statute, the relocation statute in Florida, and that is that these relocation cases are given priority on the court's docket for hearing or trial. The Florida statute is clear that an evidentiary hearing or non-jury trial on a pleading seeking temporary or permanent relief under the relocation section shall be accorded priority in the court's calendar. The courts here in Miami-Dade County are excellent about this. When they see that it's a relocation case, they always immediately start acting on it. And it makes a lot of sense because they are very time sensitive, especially if there's like an emergency with the child or economic situation or the nature of new jobs. So the parents need to get some of these issues resolved one way or the other pretty quickly. All right, that's a wrap on part 2 of our 3-part series on relocation with children in Florida. I hope that those of you who are considering relocating enjoyed this information, and stay tuned for our final episode. If you know anyone that is dealing with this issue, please have them reach out to us at www.segarralawfirm.com. We have offices in Miami and Orlando. Se habla español. If you like this video, do us a favor, hit the like button, and please subscribe to the Divorce Broadcast and share this video with any friends, families, and colleagues that may want to consider relocating and that might find this video helpful. Thank you.